let's start now. So welcome everyone to this webinar, and we're going to talk about term sheets today. But just before we get really into the topic, right, hard into the topic, I'll just quickly introduce myself. My name is Komal Shah. I am a co-founder of LawSikho, and I have more than 20 years of experience dealing core with corporate law and with corporate governance, working in various organizations like India Infoline. It's IIFL Holdings now. I manage the IPO for India Infoline. Also, I've worked out of India in BFSI entities like Citibank, like DEPFA Bank, Northern Trust. And all the time I have been involved with corporate law and corporate governance. And investment transactions is something also I have been very closely involved with. I worked with a company which was taken over twice, acquired twice. It was AIM listed at that point of time. So it was an Irish company and AIM listed, and it got acquired by JP Morgan, and thereafter with by another entity, another renewable energy organization, right? And more, however, about the investment transactions was something that I got familiarized with when I started working with the startup world right here in India. So we are, if you know LawSikho is now like, we can say that we are not in that, that startup zone anymore. But when I joined, we were very much like, an upcoming startup. We were growing, we were learning, and we were looking to scale everything, right? So that's where I got hands-on involved with the startup world, with investment transactions and with everything. Last year, we set up a function or a division where we decided that we are going to be helping bootstrap startups like us work with a lot of legal work, with contracts, with compliance, with investment transactions, with IP registrations. And in that zone, we're also going to be working with making our talent pool of students. We have a huge talent pool, like close to 10,000 students, more than that, available to the startup world. We're going to be leveraging the talent of our students and making available legal services to startup world at affordable prices, or like at effective rates. So basically helping bootstrap startups, right? So that is something that that we decided last year, and that's the function that I'm heading and building. So I would like to have a feel of of the audience here. So how many of you are founders and are looking for functioning? How many of you are employed? How many of you are founders? Can I know how many are founders? Just say yeah. Founders in the house. A lot of people have. It's a topic which would attract founders for sure, right? Brilliant. A lot of people are founders. Great. How many are employed and are are working with a company who's looking to be seeking investment and therefore interested in term sheet? How many people are employed, or how many people are in that zone, or in an employment zone? Yeah, I guess we will launch a poll for this, and that can give us a better idea. So can we launch the poll, please? Let's launch a poll. So please please answer the poll, and it will kind of give us a better idea on where to take this this webinar, how can we make it the maximum relevant to the audience? Please respond to the poll. Why am I not seeing the responses, Pratibha? Are you guys responding to a poll? It's disappeared. It's disappeared because I can't. Yeah, I can't. Yeah, yeah. I can now see. Yes, yes, yes. I can now see the responses. That's fantastic. Great, great. More than 50 people have answered so far. Great. Fantastic. So maximum of us are startup founders. Thank you so much, guys. Some are business consultants, but very good. So we have a lot of founders in the arena that can give us like an opportunity even to network. So why don't we quickly, briefly introduce ourselves, right? So I guess founders would be looking to network at maximum places. So let's have a quick introduction. Like let's see from which cities you guys are, and what businesses do you lead. Quick introduction. Someone is heading a logistics startup from Mumbai. Someone is from Delhi. Also, savings and investment at fintech. Great. Dental tech. Wow. 3D animation. Food brand. Lovely. We have a very varied audience here. Transport. Great. Hey coach. Agri-tech, ed-tech. Fantastic. This is such a diverse mix. Lovely, lovely, lovely. Very good. Thank you so much, guys, for that introduction. Right now, since we are here in a webinar where we are going to talk about term sheet. I guess many of you are in that zone, thinking that maybe 6 months down the line we're going to be thinking of funding, or maybe we are in a zone where we're already talking to various investors, or maybe we're in a zone like some of you might have already be very close to closing an investor. Okay, so people probably be are looking at understanding what investment is like, and getting the hang of term sheets or where these stand in an investment transaction, right? So let's dive right in basically. So I think most of you will know that there are a few stages which you would have to pass through for an investment transactions, right? And not all transactions will pass through these stages, but in general, this will be the sequence of events that will kind of happen in a funding transaction, right? So there will be obviously pitching and preliminary discussions that happen with investors, and then when these are successful, you will kind of uh, agree on the amount and mode of funding and everything and all of that, and you would put those terms down in a term sheet. That's where the term sheet stands. We're going to talk a little bit more in detail about the term sheet, of course, but that's where it stands. Then there will be like a due diligence exercise that's carried on. Of course, the investor wants to know where you are, and largely it will be like a business and financial due diligence. There can be legal due diligence also, which takes place where the investor tries to assess more details about where the business stands, what are the levels of compliance, what are the financial metrics of the business, everything. And then you have like, or even while the due diligence is ongoing, you will have a transaction document, right? And this is what crystallizes the terms or arrangements or agreements in a financial transaction. Now, that transaction document, as lawyers would call it, can be an I-safe, which people are beginning to pick up now. It can be a convertible note. It can be a share purchase agreement. It can be a share subscription agreement. And then there will always be a shareholders agreement that accompanies both of those, right? So this is the transaction document. Obviously, after that, there will be the disbursement of the funds, and then the covenants that are there in that transaction document get followed at a later stage on an ongoing basis, right? So this is normally like a logical sequence that happens in a funding transaction, right? So as we noted, like immediately after there are preliminary discussions and agreement about the mode and the amount and everything. That's where the term sheet comes in. And I've worked with investment transactions where term sheets would directly be provided by the investors. They have a standard term sheet. That's the term sheet you are supposed to use. They have a very fixed way or an amount of investment. They have a decided mode or an instrument. Everything is firm, and that's how they proceed. So investors which are like uh, are really experienced, right? Private equity investors or VC investors which are really experienced might have all of these things already bottom lined, and that's how they will provide to you, so I have seen transactions like that. I have seen transactions where the investee company, right, offered or created a term sheet and presented it to the investors, where your investors may not be really sophisticated, like you are getting some angels or some known people or to contribute. There can be friends and family rounds that also happen in the initial stages in a startup, right? And the investors would not really be of sophisticated kind. They are not like repeat investors, right? So in that case, the company may create a term sheet and agree something and place before them. And I've also seen transactions where there were never any kind of investments at all, like any kind of term sheets at all. You just went to the investors, discussed the business with them, and the investors, based on the idea and based on knowing the founders. Okay, most cases that's the sequence, that they know the founders since a long time. Um, and that's how they are investing, right? So there will be transactions like this where there are no term sheets which are drawn as well. Someone is asking if they can get recording for later reference. Yeah, you can, but what will happen is, like, if we are talking about it live here, any things that immediately strike to your mind, we can kind of discuss at the end of this webinar, and we can talk about it, right? Um so so all these kinds of transactions can happen. There can be transactions where term sheets are provided by either party, or transactions where there are no term sheets at all, right? Which will happen, like I said, when people know each other and it's an initial friends and family round, or the investment amounts are not that significant. Okay. Now, let me tell you about one recent experience. Right now, very recently, there was a founding team which approached me for an investment that they had been trying to secure. Like, it's a month since they had been working. I know that it's a month since initially they had talked about me sometime back, and it's a month that they had been working on it, and it was an investment that they had been trying to secure. And they came to me at a really really late stage, right? And they came to me at a stage where they had a detailed share subscription and shareholders agreement sent by the investor. Okay, they had already reached, they'd already got everything put into the investment stream. And now what is happening is, once an investor has has sent this kind of detailed document. Like, they're not going to give you a lot of time to, think and go back and come back and do all of those things, So they were under pressure that we need to kind of accept, and we need to sign, and we need to implement this. So they came to me only for the implementation of that that transaction, saying we now need to get into the share subscription and issue the shares and get the money. So they came at a very, very late stage. Now, the way the transaction was negotiated was such that if we hadn't taken care of this thing in the implementation, in the manner we hadn't planned things properly in such a way, then at one stage they would have ended up giving 10% of the company for kind of nothing. Okay, more or less nothing, no money. Okay, so these kinds of things, or these kinds of dealings, are very, 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 very risky, because what happens is that if you're talking about giving 10% of the company, there were stages in that transaction which were planned. If you did not plan it properly, then it will happen that at one stage you end up giving that stock immediately, which would be like 10% of the company at that point of time, and you would probably not proceed further in that transaction. Okay, and once you allot shares to someone, it's when I keep saying this numerous times, it is very difficult to fire a shareholder. You can fire an employee, you can fire a CEO, you can fire a director, but it is very, very difficult to fire a shareholder. Okay, like there are very less ways left. We can talk about what are the ways there and what to do in that situation, but there are very, very less ways in which you can fire a shareholder. Okay, so you would end up having someone sitting on your cap table for 10% of your company for kind of nothing that they have paid. It is very, very risky to do this, but they came to me, and what happened is I had to tell them that, look, this is a huge risk, so we need to plan, and we need to sort this out, and we need to plan it in such a way that you don't end up with this risk getting materialized. But these are the kinds of things which can be taken care of when you actually have a term sheet and you think the thing through, right? And you know that this is how the transaction is going to progress, this is what is happening. So at that stage itself, you agree everything. Okay, so that there are no surprises that spring in that in the transaction document. And once investors have given a transaction document to you, and they want you and maybe some existing shareholders, friends and family who have been there in the company, they will be very much on that, get it signed, and it's a risk for you also. I mean, like, you don't get it, you don't progress with it on a very, very fast way, chances are the deal can fall off. You don't want to lose the investment also. So it's very, very important that these kinds of terms or these kinds of things get agreed before it, and then it gets transferred to the transaction document, so that once it is translated into the transaction document, you're not going to take much time, because you know what is going to be there. Okay, so that is why a term sheet comes very handy and very very, very, very important. Now many people will say that, look, I know the investor knows me, we have been working together for a very long time, or they have been my mentors, or they are my rich cousins, or whatever it is, they know me. So I mean, these kinds of things are not going to happen. I'm not going to get a surprise, because we kind of know each other, right? And this also has happened with me, you can't say really that we know things we know each other, and therefore it's not important to have these things or detailed, or we are not going to have any problems in the future. I can tell you one deal where someone actually got funding or money from their friend who was an NRI, and then the what happened was that the company grew after taking that funding initially, the company grew, like, and they're looking to take more rounds of funding. Now, this guy who is the rich NRI cousin is not very much happy about, these next rounds, because his shareholding is going down, 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 down to a very minuscule part. And nothing has been agreed between both of them about what is going to happen for your shareholding. Okay, so now, like, with this disagreement, the founder will even try to offer that, okay, fine, you exit, and I'm giving you an exit price and you exit now, right? If that's the case. And then he doesn't like the exit price that is offered also. So that, I mean, the situation there, like between the both of them is, I helped him at, like, at the time when he needed, in the very early stages, and now this is the kind of return he is giving to me. This is the price I'm paying for helping someone at very early stage. So it's like, a fallout in the family between the both of them, because nothing was agreed or talked about or discussed, and that feeling was that, it's okay, we know each other, so what is going to happen? Okay, but that's not how it is. If there had been an agreement, if there had been points, there had been discussions on, like, see, this is what will happen, this is how things will go, this is how things will progress, this is what is going to be an exit price should you look to exit, everything, if it had been decided beforehand, right, this kind of issues or this kind of problems would not happen. Okay, so this is where your, like, where the term sheet comes handy. So bottom line is that you have to put it down in writing. The only thing, that is the only thing, that's what exactly a term sheet is. You need to put the points down, you need to put the terms down in writing before you take the money, so that, both the sides are very, very clear, and there is no surprise, there is no misunderstanding that comes out at a last stage. Because when you reach that last stage, it's very, very difficult at that point of time to overturn everything and say that, this is the shareholders agreement and here are 5 or 6 changes in the shareholders agreement. Okay, investors don't like that, right? People don't like that, you reached an advanced stage and then you say that here are the things that we need to change because it doesn't seem acceptable, right? So that's why it's very important that you have it there at that stage, in the initial stage. Okay, so what would the term sheet contain? Now we'll say that, okay, the terms we are going to put down. So what are these terms? What are the kinds of things? I mean, people will end up using, like, words like reverse vesting and anti-dilution and, right of first refusal. What exactly are all of this? What does this come? I would believe that most founders are really familiar or understand the logic of these clauses, but still the way these get worded in agreements, it can sometimes throw you off gear, that what does this really mean, like, and what is the sense of, what are the implications of this? Most important. Okay, that is something that people will feel, that what are the implications of these clauses? I can't, I mean, it's very difficult to actually read through a legally filled shareholders agreement and come to a conclusion of what that means, right? So like, if I give you a very general idea or very simple idea, if in a term sheet, obviously there will be clauses, boilerplate things like confidentiality and your jurisdiction and all of that. But that apart, two main parts or two main elements would be that after the investment. So main part is obviously the investment, that what is the amount, what is the mode, or what are the instruments in which the investment is happening. Those kinds of things already have been decided between both the parties. So it's not something that will, like, that will be a surprise, because obviously the amount, the mode of investment will have been discussed. That is not a surprise that can show up at a later stage. Where you need to be very careful is, there are two types of clauses. One is those which are related to how will the ownership in the company be managed after investment. Okay. So any changes that are going to be in the ownership of the company after investment, how are these going to be dealt with? That's where your lock-ins or reverse vesting or right of first refusal and those kinds of clauses come. And the second is, how is this company going to be managed? Okay, who's going to be calling the shots? How will the decisions be taken? What is the participation of both the sides, the founders and the investors, in the decision making? Those are the two types of clauses where you would want the maximum attention to be there, because there can be something which can throw things off gear, and we'll talk about that a little bit later on, how things can be like surprise and how they can take you totally off gear. But uh, basically these are the clauses, right? These are the kinds of clauses. We have a couple of questions. Can we talk about the questions really after we are discussing this, because we just quickly need to understand what these things are, right? So I'm just going to share a slide, a few of the clauses, and we'll just make it in a very simple understanding that how do these affect the change in ownership. That's it. Okay, once we get that, we'll be able to look at a term sheet, and we're going to be able to think of that. So when you see this in a term sheet that's offered by the investors, or when you think of, should I be putting these things in my term sheet and clarifying this with the investor? Okay, this is what you want to think of, like the ownership of the company and the management of the company after the investment is made, right? Let me share my screen. Yeah. So these are the few things which you may want to think of. Conversion terms, maximum investments. If people have been really familiar, maximum investment will be in terms of preference shares. Why? It's because it's an instrument which is suitable for a lot of different things. We can talk about preference shares at length, like in different ways, but that's where maximum, that's the instrument in which maximum investments will take place. So in order for that to give you some sort of ownership in the company, I mean, you were giving preference shares to an investor. If he's looking for ownership in the company, he would want those to be converted. So maximum investments take place in convertible preference shares. Okay. So how are these going to be converted into equity is one term where people will, it's even for lawyers, it's like a thought that how are we going to convert them, what is the rate or what is the conversion ratio, that and how do we fix it? Okay, but that is one thing that you have to think, and though it seems technical, you will have to grasp, because at the end of the day, that will decide how much ownership you end up giving away to the investor at a later stage when that conversion happens. Okay, lock-ins is that people are not going to be able to transfer the shares. Founders have to keep it, investors have to keep it. Can transfer your shares to someone for a certain period of time, because it's not healthy for the company to see ownership changes that frequently. Okay, preemptive rights simply means that if the company is going to have additional shares, issue additional shares, then who should it issue it to? Like, do the existing people get a right to get offered those shares first? And that's what preemptive rights are called, right? Am I going too fast, or is this understandable, or is this making sense? Or so far, how is it seeming? Can I have some views? Can I have some views? Like, is am I going too fast, or is this logical and it makes sense, right? Yeah, thank you guys, thank you so much. Okay, great. So like, this is where you are some terms are not getting it, maybe problem, but some are not very familiar. Obviously you are not familiar with the terms, right? But you have to note that all of these concern the ownership of the company after after investment. And that's why it's very, very important. Okay. Who is going to own the company after investment? Okay. That's where these things deal with. So preemptive rights. Right of first refusal. It simply means that if someone wants to sell the shares and someone wants to exit the company, exit their investment, they're going to have to offer it to the other person first. Okay. The other person has a right to refuse first. Okay. So you have to offer it to the other person first. And if they say no, if they refuse, then you can go out and offer it to a third party. But between the both of you, between founders and investors, you need to offer it to the other party first. That's a right of first refusal. Right of first offer is not commonly used in investment transactions. I have kind of never seen it being used. It's more used in property related transactions, but I can just make a reference to it. I've not seen it being used in any shareholders or share subscription agreements. But what happens in the right of first offer is that in a first refusal, you say that, look, I'm looking to sell my shares at 100 rupees. If you want to take it, then you take it. Otherwise, I'm going to offer it to another party. In a right of first offer, I am saying, I want to sell my shares. Now you come and offer. You come and make an offer on it. You have a right to make the first offer to me. Okay. And if someone says that, okay, 100 rupees, then the thing is that I cannot sell it at lower than 100 rupees to the other parties. So the buyer, who's going to be the person who's going to buy those shares, has the right to decide the price or offer the price. In a first refusal, it's the seller is saying that I want to sell it at 100 rupees. Okay. So that's just the difference between right of first offer and right of first refusal. Reverse vesting. This is something which I have not seen in many shareholders agreements as such, but it can still be there nevertheless. Okay. And what happens in this is that founders who are there in the company, because many times, and you have to understand the logic of this, many times investors invest in a company only because of the founders, the strength of the founders. They trust the founders, they trust the ability of the founders to take the company forward. Okay, that's the reason that they will invest. So for obvious reasons, they don't want the founders to leave. Okay, so in a lock-in, it's very straightforward that for 3 years, you can't sell your shares, which means you can't leave or exit the company. In a reverse vesting, it's like your own shares, which you hold, the shares which the founders hold by themselves, are kind of locked. Okay, so you don't have the rights to your own shares. You get the rights to your own shares on a staggered basis. Okay, so for the first year of investment, only let's say 10% of the shares of your shares are available for you to deal with as you please. After that, it's 20%. After that, it's 30%. After that, it's 40%. So then it's like 100% over a period of 4 years. So reverse vesting. Okay. Even though you hold the shares, you don't hold the rights to the shares. The rights to deal with your shares as you please only get released to you in a staggered basis or in a staggered manner. Okay, and this is again a mechanism to keep the founders invested and interested in the growth of the company, so that you don't go out and you don't let's say set up something else, another business, get more interested in it, and then leave this company to the dumps. The investor doesn't want you to do that. So that's why there is a reverse vesting clause. Anti-dilution, and we're going to talk about how dangerous this clause can be, okay, a little bit later. Okay, anti-dilution is where the investor says that I don't care if you go and give out shares to other people and you get more money. You cannot give shares to the other people at a price lesser than what you gave the shares to be. Okay, because it will reduce the value of my investment and I can't take them. If you do that, then you have to give me additional shares so that the value of my investment stays the same. Okay, that's what basically the anti-dilution clause is. Okay, so that these are all dealing with the ownership of the company, because understand that your cap table, your percentage shareholdings, everything will get affected by this. Okay, Anyone has any questions so far on what's not clear? Equity financing or debt financing? I'm talking about equity financing totally. In most cases, it turns out to be it tends to be convertible preference shares. Okay, so it's like it is like equity financing because it's an instrument which is convertible to equity. Okay, that's what it is in most cases. Yeah, so anti-dilution is that kind of rule which the investor will say that they don't want their holding or the value of their investment to be diluted. Until it is the value of the investment, it's okay, but there can be other ways in which anti-dilution clauses can be worded, which can be like which is not acceptable. We're going to talk about that a little later. But that was the ownership related clauses. Now these are the management related clauses. How is the company going to be managed after investment? Okay, so composition of the board. Does the investor want to put someone on the board? If they want to put someone on the board, is that person going to be the chairperson? Is that person going to have a casting vote? Is that person going to be the person who breaks the deadlock, which means that things will always be in favor of investors? These are the kinds of things you have to think, right? Because logically you may think that fine, it's one of my representatives, one of the investors' representatives, two people there on the board, or two of my representatives, two of investors' representatives, equal representation on the board. But then one of them will be a chairman who will have a casting vote. So obviously then it becomes 3:2. So like, these are the things that you have to think of, that what is the composition of the board and how are decisions taken? Because factually, like, the day-to-day running will be by the board, not by the shareholders. So you have to think of how the board is framed. Okay. And then most investors may not have a nominee. They'll not put someone as a director. They'll say that we're going to put someone as an observer. Okay. So what happens with this observer is that that person will just remain present when the board proceedings are carried out. Okay. Which means that you will actually have to have board proceedings be carried out. Okay. Until now, you were functioning with, you and your friend who was a co-founder sitting down for a cup of tea and classifying it as a board meeting. Not anymore, because now that observer is in place. So they will ask for everything. They'll ask for information. They'll ask for documents. They'll ask for what decisions you are taking. Okay. So observer on the board who must be given like, any kind of notices for board meetings, and, who will stay present. And they do not have a right to vote, by the way. They can't vote, and they can't swing the decisions in any manner. They'll just be there, but they are there. So they will observe what happens in the proceedings of the meetings. Okay. Reserved matters. Now, there are two things about this. One is that they will reserve the thing that these decisions must be taken at board level. You cannot delegate it any further. Okay, so you get an appoint a CEO, a COO, a CTO. You cannot delegate your decision down to the level of CEO, CTO, or COO. These are the few things. Okay, let's say a capital investment of beyond a certain amount. You cannot delegate down to the CFO to take that decision. We want that level of discussions be at a board level where, the investor is involved, so that they can have a say in it. Otherwise, you will simply say, okay, delegate it to CFO level. CFO has taken the decision. All right. And you will bypass the investor's nominee who's sitting then on the board, but that's not what will happen. So they'll say that these decisions have to be taken at the level of the board where we are involved, where we are sitting, right? And affirmative voting rights. So this is where if you are doing 1, 2, 3, 4, 5 things, then we must have voted yes to it. We must have said yes. Only then you can proceed with those things, right? So, and these are the things like that, borrowing beyond certain amounts, capital investments beyond certain amounts, hiring of really key employees who have substantial decision-making powers. Okay, these kinds of things can fall in the affirmative voting rights. Obviously, things which have directly to deal with the existence of the company, amalgamation, merger, all of these will fall in this affirmative voting rights category. But other than that, decisions which are really important, even in the day-to-day running, can also fall in this. So the investor will want a say in how the company is deciding these matters, right? So these are some of the things that get into the shareholders agreement, and it helps if we have a very clear idea of how we are going to put that in the term sheet. It helps if you put these kinds of things in the term sheet, okay, and you have a very clear decision that what is going to get into the shareholders agreement at a later stage. Okay, so you put these right there in the term sheet. Okay, so I think I'll stop the share now. But these are the two kinds of decisions which are related to ownership and management, which should be there, and which you need to take care of, right? Other than that, there can be covenants, or there can be things which are related to information and inspection of the documents of the company. So they can kind of say that, okay, once in a year you have to give us the business plans, you have to give us the audited financial statements, so that we are kept informed about the investment. Okay, investors who are not strategically involved in the business but they want information, they can have like information covenants like this. Okay, so they'll say that you must provide us this kind of information, maybe budgets, like a budget for the company. If you're discussing that, that should come to us. Okay, now in each of these terms, okay, there is a scope that the investor can swing things and make it excessive. Like I said, they can put a chairman who has a casting vote. Okay, so like that, there is a scope, or there is a chance for an investor to make things excessive, okay, in each of these terms that we are discussing. So that's why you have to be very careful when you read that nothing in this is excessive, or is like against, or it's not in favor of the founders. Okay, I'll just give you a few examples here. One huge, or one important clause is a drag along clause. How many of you have heard about drag along clause? Can I say heard? Yes, drag along clause. How many of you have heard about of this? How many have heard? You have heard that there's a drag along clause. How many of you have heard of this? It can be pretty dangerous. Yeah, someone says drag and tag along. Never heard of it. Wow. Anyone else? People are not. Anyone knows of a company? I mean, it's not that popular now, or it's not that famous, but people heard of a company called Snapdeal. How many of you heard of Snapdeal? It's like, it used to be a competitor of Flipkart, like right up there with Flipkart at some point of time. People heard of Snapdeal, right? And yeah, Amir Khan ads. People remember Snapdeal for Amir Khan ads. Yeah. Well, yeah. So this Snapdeal, there was this very famous case of the drag along clause in the Snapdeal agreement, because Snapdeal was at one point going to be sold to Flipkart. Okay, they had this huge bunch of investors, and they were led by SoftBank. How many of you heard of SoftBank? Lead investor, people who are here in the term sheet and looking of investment. How many of you heard of SoftBank? Lot of investments in India, right? So SoftBank was this very lead investor in Snapdeal, and they had this drag along clause. Okay, so now what happens when you have a drag along clause? Just one second. So they famously had a drag along clause, right? And drag along clause is where you have a major investor, a lead investor, someone who's holding really high number of shares, and has kind of calls the shots. That person can force, or drag, okay, pull the other shareholders to sell the company to someone else. That major person, if they are looking to sell the company to someone else, they can drag other shareholders with them. They can make the other shareholders sell their shares to a third party. Okay, and SoftBank had gone ahead and they had kind of exercised, they had gone on for exercise of this drag clause, where they were going to make the founders who were at that time holding minority shares, they were going to make those founders sell their shares to Flipkart. So just think of it, the company could have been sold with that just one clause, because the investor had that kind of right. They had a drag right. They could pull the founders to sell the company to someone else. Right? So they had these drag rights and they could have sold, the company to Flipkart. What are tag along rights? We're going to talk about it later. And that is a minority protection right, but like this is a dangerous clause. So let's understand this first. Okay. So they could have sold it if the founder hadn't brought in, he went ahead and presented the Snapdeal 2.0, and like that the board got convinced and continued as it is. But otherwise that clause was there, it could have been sold, right? So it is that relevant that it can result in your company getting sold to someone else. Okay? The drag clause is that important. And most of the times we kind of, getting the money, so why, we know the investor, so why? Okay. So these are the things that, we have to clarify and we have to think of when they put this in the term sheet, and it should be sorted right there at term sheet stage. Okay. In general, tag along rights are, when a majority is actually going ahead and selling, the minority can come and say that, take me with you. Okay, they can say that if you are selling, then I have a right that you take my shares and you sell it to someone else. Okay. Mostly it doesn't come to that for founders. So it's not, it's more of a investor protection right for a minority. Like if the investor is holding a minority, that's where this is more relevant, right? So the drag, then anti-dilution. Anti-dilution was something that I was saying, that it's again a very dangerous clause now. And this is very recently, I saw one agreement in which what was happening is that there was a company that had an investment, and that investment was at 51%. So obviously they were the company was the holding company. Okay, it was a subsidiary of that. But the founders had the remaining 49% shares. Okay, it was between two founders, remaining 49 shares are divided between the two founders. Okay, and the company is coming in at 51%. So holding the shares and keeping the company a subsidiary, making the company a subsidiary. More or less, it's an acquisition, right? Because it's where it is getting the holding rights or main rights in the company. But the other two people had 24.5% rights each. So 49% between the both of them divided. Now, what they had in their agreement was that if you are taking investment from someone else, okay, the investor, which is the acquirer, and the company which has 51% rights, still continues or does not, disturb the holding status. Okay. So you go and take your investment from someone else, but throughout the life, the holding status of the investor company or acquirer company should not be disturbed. You know what that means? It means that if there is someone else who is coming, the founders are mandated to transfer their shares, and they will keep going down from 24.5% in the company at whatever rate that person is coming in at that point of time. And the acquirer will maintain its 51%. And if you read that, you would not even, if for a normal founder, and these two guys were in the medical profession, by the way. Okay, they were not. So if you read that, you would not even realize that this is what is happening, and my shareholding tomorrow is going to continue to go down in this company. Okay. So these are the kinds of things. So anti-dilution right, it was like a very disguised and it was a very it was an anti-dilution clause put in a very disguised manner so that you won't understand. It means that our holding from 51% will never be diluted. And whenever someone else comes, you have to transfer your shares. Okay. And whether the founders agree at that time to transfer or not, why would they? Like, they may foresee the value of the shares to increase 3 years, 4 years down the line. But this agreement was mandating the share founders to transfer their shares. So these are the kinds of things that can happen, which, if you are not careful, it can be clauses like this. There's another very dangerous clause called material adverse effect. And this is more dangerous because the most important thing for a founder in an investment transaction is that I want to keep the deal. I don't want the investor to go away and I don't want this deal to fall off. Okay, I want to get the money and I don't want to lose that. That's something that's very important. But this material adverse effect clause is something that even if you've entered into a transaction document, you have signed the transaction document, still it can result in the investor reaching a stage where they're going to sign off and they're going to say, no, it's a material adverse effect. We are not going to give money to the company. After all the time and all the negotiations that have been wasted, the investor can simply say that, no, I'm not going to give you the money, because what I see here, or the change that has happened here, is a material adverse effect to my investment. So I'm not going to make the investment. You have to be very careful that this clause is there, which is not excessive. Okay, because what will happen effectually is that the investor may have found a better deal to invest in, and after all of these things, after all the exercise, after everything, they will still go and put the money to a place where they are getting a better deal. Okay, so if you have not bound them to exclusivity, and if you have not done things where you are this can happen, it is like muh pe aake niwala chala gaya, that kind of thing this material adverse effect clause can create. So you have to be very careful on having these kinds of things. Excessive information covenants, sometimes what they will do is in the guise of providing investors information, they can put covenants which will be like, even if you move, you have to let us know. Okay, it will be something like that. It will be so stringent that you have to inform them for everything. Quarterly, you make your quarterly accounts, you have to inform. You appoint someone in this position, you have to inform. You have to do something, it will be a very, very stringent information clause which you don't want to agree with. It's like, they are like a grandfather, and for every time you have to go to them and talk to them about what is happening. Those clauses can also be there in this, and therefore these kinds of things can be there in an investor provided term sheet, right? And you have to be very careful when you read that this is not happening with you. This thing will not be, obviously it will not be put by you, but it can come from a term sheet of the investors. They will get you to sign it. Simply it will be translated to the shareholders agreement and you are done, right? So these are the things which you have to be very careful of when you get a term sheet in order to review, right? Some other things which you should get the investors to do, or if someone is really interested, you should actually try to make them commit to that. And one of the very important thing is that you should try to have them put money in an escrow. Okay, and many times, very recently, in fact, I did a transaction. I was working on a transaction of acquisition of an Australian company. This is not Indian, but it was an Australian company, and there was an intermediary helping the sale of this transaction, and they provided escrow services. So, the insistence was that in order to buy the shares, you put the money in the escrow. Okay, you don't give it to the founder, but you put the money in the escrow. Now, you may not be getting the money, but the very fact of the investor putting the money in the escrow is kind of a commitment. Okay, people will hate after taking one step forward. They will hate unless something is very, very out of place. People will hate to take it back and take it out and release the escrow and not go ahead with the investment. Okay, it's so investors would they try to make the investors put the money in the escrow so that they kind of get a commitment that the money is going to come to us when everything is done. It may not come to us today, but it's on its way. It's somewhere in the middle. It's out of the investor's bag. So that is something that founders can try to do, because it amounts to an additional commitment, and it is more of a signal that the deal is less likely to fall off at a later stage, and you will probably get the money. Okay. Exclusivity is you have the investor to agree not to shop around while the negotiations are ongoing, or while due diligence is ongoing. Very, very difficult unless you hold, or unless you have that kind of power to keep the investor. But if you get that, then very good. And you should actively manage or keep an eye on the shareholding percentage. Okay. And you have to think of what are the things that are going to be in our control. For example, if you have an ESOP portion or an ESOP pool that's carved out of the cap table, generally employees will be in your favor. They're not going to go and be out in the favor of the investor. They'll be in your favor. So you should have an ESOP portion that's carved out right at the term sheet stage. And you can say, well, I can get the ESOP at a later stage. But you do that right at that stage itself. In fact, the investor will see you as a progressive company, that you are thinking to have an incentive scheme in for the employees, right? And they will agree to this, with not much difficulty at the term sheet stage. You go and introduce it at a later stage after you have showed them a bigger percentage of shareholding, and then you say that no, I want to carve out this for ESOPs. It can become very difficult. So you have it right at the term sheet stage itself, right? So basically, you have to think of all of these things. You have to think of the control and management of the company, and you have to think of what is the cost at which I'm getting the funds. Am I ending up giving my ownership and putting my ownership to risk, that 51% anti-dilution clause did? Am I ending up giving too much in the management of the company? Okay, you have to think of what is the cost at which you're getting the funds, and that's what gets covered in the term sheet, right? So, and the funny thing is that, if you actually negotiate with an investor like this, you actually go and tell the investors that these are the few things, that we want to put in a term sheet and we want to agree on. These are the things that we need to discuss and we need to talk about. They'll think of you as an aware or an informed founder. In fact, it can increase your respect in their eyes versus someone who is we agree to whatever you say. Because then they'll say that what is the capacity of this person to lead the company? If he's thinking and if he's talking or negotiating these terms, it will actually increase your respect in the eyes of the investor when you are talking about this, right? So that's why it's essential that, when you are having a term sheet, you have all of these points underlined, and you have someone to take a look at it for you, to have the things decided and planned out and organized logically. Okay. But it's more important that if you're having a lawyer look at a term sheet, they actually explain the implications to you. They tell you that, look, if you have this clause, this is what is likely to happen. Okay. It's not just they say that this is good, this is bad, and these are the changes in the term sheet. No, they need to tell you that what is the reason, or what is the change, or what is the point in having this thing or not having this thing, or what is the point of the change. They should be able to explain that to you, okay, about why they're doing what they're doing. And I'll tell you why. Because founders are, however highly qualified a lawyer may be, founders know their business the best. Agree? How many people agree this? How many people agree with this? This is my theory, and I believe this very firmly. Founders know their business the best. Okay, lawyers can know terms, lawyers can know law, lawyers can know implications of law and everything, but founders know their business the best. So unless you have a lawyer or you have someone who's actually going and explaining that this is what is going to happen, and you are making an informed choice, okay, whether this should be there or this should not be there, it doesn't make sense. Okay, you have to have that right of choice, and you have to be able to make the informed choice in the terms. Okay, so you will have lawyers who will put time, and they will just make the changes and give you, this is the red line and track changed version of the term sheet. Now, I mean, you do what you want to take forward with it. It doesn't work like that, right? We don't do that. Okay, so that is like kind of the difference between how LawSikho works and like how you will find a typical law firm to work, because we are not a law firm. Okay, so we are actually an ed tech, right? So the reason we are starting this function, which I'm leading at the moment, and the logic behind this function is that on one way we want to be helping bootstrap founders. We are bootstrap. LawSikho is bootstrap. Okay, we want to be helping bootstrap founders with like their contracts or their compliance or whatever things works for them, like their legal requirements, including for investment. And on the other hand, we want to leverage the immense 10,000 talent pool that we have, okay, of the lawyers. So the students that LawSikho has are not totally law students. Okay, there will be there. It ranges from a first year law student to someone who has 15 years of experience. But let's say this guy has experience in IP, but they now want to work on like investment transactions or something like that, which is why they would be willing to work at a lesser cost. Okay, if you go to someone who's in that field and an expert at that field, they're going to rip you off. Okay, investment transactions, typically shareholders agreements, term sheets, these kinds of things get charged massively by law firms who are in the expert zone. Okay, but we want to leverage this power of someone who's wanting to diverse that and put their experience, and also a startup who is looking for affordable legal services. And that's the reason we created this function, and we created an Upwork agency. I want to just put the link of the Upwork agency. You guys can have a look at what is the kind of work that we do in the Upwork agency that is carried on by LawSikho, right? So this is the kind of let me just share. This is the kind of work that we do. If you go to that link, you will be able to see the work that LawSikho does, and also the testimonials of what kind of deals we have worked on. Okay, we worked on a lot of investment transactions, right? So that's why we started this LawSikho Upwork agency, but that's only half part of the story, because like the other half is, let's say we did one agreement for someone, and then when they had their investment transaction, they came to us. Okay, so it's like we have a lot of connections, a lot of work that is outside. We're helping or supporting a lot of founders outside Upwork also, because Upwork is basically a US platform. So like if you look at Indian founders, it might even be a bit of an issue to put things up and then set things up and again give and all of that. But we do like a lot of work outside of Upwork as well. But it was started with this intention, right? So if you like help, if you would like help, if you want help with creating a term sheet for yourself, if you are looking for to seek angel investment, or if you are looking to, if you've got a term sheet, or if you're talking to investors and you're going to get a term sheet from them, and you want to like think of and understand what are the implications of this on my business, let me decide that, and let me understand and make an informed choice. Okay, so that's where we can help you. Okay, and if you like help in this, then here is where you go. Let me just put this. If you want help with your term sheets, okay, review with your term sheets, discussion on term sheets, what are the kind of terms I should offer to the investor, okay, or things like that, anything that's relating to funding. How is the funding likely to go, like all of those things, okay, in the terms. What are the instruments I should choose when I'm talking or negotiating with investors? This is where you can come, and we can talk specifically in detail about your business, and how you should phrase out the terms, or how you should work on the terms for funding for your business specifically. Okay, because every business has its own way of working. Every person has its own situation. Every person has different category of investors. Okay, so obviously the things will differ from situation to situation. So if you like to have like a discussion on the term sheet, here is where you can actually go. Okay, and we can talk, we can get on a call, and we can discuss this, and we, like I said, we will actually understand the implications of how these clauses pan out. Last night, I was on a call with a founder for 2 hours on an agreement in an e-commerce company. And we ended up actually strategizing a lot of things. Okay, so when we were talking about the agreement, we didn't have all of this in mind. But when we spoke, we ended up strategizing and panning out like, a lot of things or processes for the business. So this is the kind of things that can happen, right? And if you want to keep in touch with me, I'm always up for like, discussing things that are startup, that are, or I'm always into them, totally in that zone. So I just share my LinkedIn profile link and we can, keep in touch on that. You want to share, you want to talk about all things startup, here is what it is. So this is my LinkedIn link, like, we can keep in touch. I'll be very happy to chat with you on different things, right? Great. So guys, we are already 10 minutes ahead of the webinar. I hope that, we get to talk a lot on, your investment transactions. And I wish that all of you get success in getting the funding that you're looking for and you end up getting, the right kind of terms. So we were wondering, will you be open to help for companies started by Indians abroad? Yes, I do. In the last couple of months, I have helped create 3 Delaware corporations. Okay, 3 Delaware C corps. Last 2 months, right? So we have like, done this kind of thing. Mentor, advisor, well, why not? Like, of course. So open to that, definitely. But we can talk, like I said, we can discuss more about it. So just like, I have shared everything. Self-paced course, you can visit our website. Most of these are more like, for someone to help startups, because that is the intention here. So we'll be training lawyers to help startups. Okay, obviously coaching or helping the startups comes with it, but we are training people to help startups. So it is more of that sort of course rather than a course which a founder will take up. Okay, so it's a very different perspective, but you can go check out courses here, LawSikho.com, and you can find or you can see something that might happen. You can visit the website and you can look, right? So convertible note, term sheet preparation, everywhere. So any kind of specific help that you need with your business, guys, this is the page. Let me copy that link once again so that you have it. This is the link. Okay, so this is where you can take a chunk of my time and we can talk. It will talk of 30 minutes, but obviously in most cases never gets over. Email ID, you can reach out to me on LinkedIn, right? So I hope you guys like found the value, and we can talk more about your business later. Okay, so thanks guys, have a great day, and all the best to you. Thank you. Bye.